Healthcare consent laws from Generations United. I'm Jaya Peterson-Lent. I'm the Deputy Executive Director here at Generations United, and we welcome you to this webinar with presentations by Anna Beltran from Generations United and Judy Lynn from King County Bar Association in Seattle, Washington. We are going to start by just covering a couple of housekeeping options, and I turn it over to Adam Otto from our staff to do that.
All right, I'm Adam Otto, the Program Policy Assistant. So your phone is muted throughout the presentation, so you won't be able to talk, but if you do have any feedback for us or questions, feel free to type them into the question box, and we will answer them at the end of the presentation. The webinar is being recorded, and the slides and the recording will both be posted online by next week for you to access, and then we'll also be sending out a short survey after the webinar that we would appreciate if you filled it out. There also might be a slight delay in transitioning the slides, so if your screen doesn't transition right away, don't worry, it's normal. And I think that's all for me. Anna?
Hello, everybody. My name is Anna Beltran. I am a Special Advisor with Generations United. I now live out in Seattle as well as Judy, but I used to direct Generations United's National Center back in D.C., and now I work as a Special Advisor here. Judy, would you like to introduce yourself?
Sure. Thanks, Anna. My name is Judy Lynn. I'm the Senior Managing Attorney for the Family Law Pro Bono programs at the King County Bar Association. Here at the bar, I manage our Kinship Care Solutions project, which provides legal representation for kinship caregivers in custody cases through volunteer attorneys who I train and mentor.
That's so great. Well, thank you, Judy, for joining us. And we also want to thank the Annie E. Casey Foundation in Baltimore. They make this work possible, and we thank them for their support and partnership. And you'll see their website there, which has a lot of great resources and free publications on it. Today we are going to do a number of things. We're going to briefly go through the background, the reasons these consent laws are needed. We're assuming since you all are on this call, you're probably quite aware of kinship families and are looking for ways to help them. So the background will be limited. Then we're going to go through essential elements of responsive consent laws. So really get into the nitty-gritty of what these laws should contain in order to be most useful. And elements to avoid, so a few things that are better left out. Reasons some states may lack consent laws, the political and environmental reasons, the political environment reasons some states may lack consent laws, and tools and strategies to enact these laws. And then I'll turn it over to Judy, who will talk about Washington's health care affidavit. And then we'll end with some resource information and hopefully a good Q&A session with you all. So we do encourage you to type questions as they occur to you in the right-hand panel, and we will get to them at the end. So in terms of background, basically children around the U.S. are being denied access to education and health care solely because they're not being raised by their parents. They're being raised by someone else. About 2.7 million children are being raised by grandparents, other extended family members, and close family friends. This may be a smaller number than you're used to seeing, and that's because this is a number that excludes those households where parents are in the household or where parents come in and out of the household, in the cases of, say, substance abusing parents where they may be present sometimes. So this is just purely grandma and grandchild in the house type numbers. Many of these children are being raised by relatives without any kind of legal relationship, like legal custody or guardianship. And they do so because that's the way they want it, and I'll tell you why. And then also only a limited population is living with relatives in foster care. So that's what we're talking about when we talk about raising these children informally. Not the best word because it's a very formal relationship to them, but it's not formal in the sense that there's no legal relationship and it's outside of licensed foster care. So that's the population that these laws help, and that's by far the largest population of kinship caregivers. For example, there's about one caregiver in licensed foster care for every 25 relatives outside of foster care. So it's a much bigger population that we can potentially help here. Now, why do some caregivers not want a legal relationship with the children they're raising? Because the legal process can be exhausting, and it can be time-consuming, and it can be expensive, and it can be hard to find a lawyer, and it can change family relationships. You know, it can put a family through a lot of ordeal. It might be the best option for some families, but this just gives them another option. And in the cases of some, it gives them an option until they can get legal custody. So it kind of fills that interim gap. But if there is no consent law and there is no legal relationship, families face big barriers. Accessing health care can be a huge challenge. Even if the child has health insurance that the grandparent can access, doctors, healthcare providers can't provide services to these children without consent, and or else they open themselves up for liability problems and confidentiality issues and all kinds of things. So they need a legal consent from an adult, and that's what these affidavits give them. So, and then in terms of accessing educational enrollment and services, the reason that can be a challenge for many families without a legal relationship is because most school districts have what's called residency requirements. And that means that where the parent lives is where the child can enroll in school. Well, if the child isn't living with the parent, then some school districts say, Grandma, you've got to show us that you've got legal custody or guardianship of this so that we can know that you're not just school shopping and Mom's not just using your address because our high school is better, but you're actually raising this child. So it's legitimate concerns that are having school districts impose this requirement. But the problem is it's inadvertently and unjustly discriminating against our families. So it's preventing children who are being raised by relatives from enrolling in school. And then there's often the flip side of that, which is caregivers can't get the kids enrolled in school, but on the other hand, they're being held responsible for violating truancy laws. So it's a double-edged sword. So that's the void and the problems that these consent laws, or in many states now, this is kind of an old-fashioned term, the consent law, because these things have been around for a while, but more and more states are now calling them authorization laws, and it's because of consent often connotes the consent that adults need to provide for pregnancy termination, so authorization laws sometimes are used instead. But these generally, what these laws do is they allow a caregiver to complete an affidavit under penalty of perjury saying that they're the primary caregiver of the child, and then they give the form over to the school or to the healthcare provider, and they can access those services. And these laws, what they do is they typically protect the parent's rights by stating in the notice provision that they can rescind the affidavits at any time, and that the caregivers do not get legal custody through this affidavit. They also shield healthcare providers from liability, from taking these affidavits and relying on them. California seems to have started this trend, so one of our western states here, back 20 years ago, and now about 25 states around the country have healthcare consent, and a few less have educational consent. Annie Casey Foundation Stepping Up for Kids report, which is the Kids Count essay that they did in 2012, that we still rely on. It's got some really great data and statistics in there and useful information. It recommends that states without these laws enact them. So we are taking that report and giving tools to states to enact them. Now, this slide tells you which states in the West Coast have these laws. And keep in mind that it's very hard to track these laws because you have to use the right search terms. And, as I said, some states call them authorizations, some call them consent, so it can be tricky. So we may not have captured them all, and if we haven't, I'd love to hear from you, so please use the box on the right or send me an email, because we want to get this as accurate as possible. But from as far as we know, this is what it looks like on the West Coast. Now, I want to distinguish our consent or authorization laws from power of attorney laws. Almost all states have power of attorney laws, but they require the parent to convey the authority. So although they can be a great option and they can convey more powers often than consent laws, they can pose a real barrier for some of our families in that they're of no use if the parents can't be found or if the parents are unwilling to do some kind of legal document like this. They might have mental health issues and just not understand it and not be willing to sign anything. So they don't work for everyone. But it's another important option to have in the arsenal of options for these families, but they don't take the place of consent laws. And on the next slide, you'll see the states that specifically call out the use of these power of attorney laws for our population. But as I said, almost all states have them. So if you don't see your state listed, I would still expect that your state does have a power of attorney law. So now we're going to get into the essential elements, kind of the nitty-gritty of what these laws should include. And on the next slide, you'll see kind of the big 8 key elements that we think they should include. Putting the form for the affidavit in the law itself, covering comprehensive health care and educational services, allowing the caregiver to complete the form without the parent's signature. Again, getting to those families who can't find the parent or the parent's unwilling to sign a legal document, addressing parents' rights, shielding the providers from liability, giving penalties for fraudulent consent, and those penalties are usually stronger for educational than health care for those reasons that we touched upon earlier. Allow consent to be valid until rescinded rather than just a 1-year re-up that has to happen in some states, and permit all full-time caregivers, and by that I mean victim kin, so godparents, neighbors, people who are like family, to complete the affidavits. And I'll get into more details on all of these, starting with putting the form in the affidavit. So this can be very useful because if it's in the law, caregivers can just go to the law and access the form. And then you don't have counties arguing about or having separate forms in their particular county, or wordsmithing that happens during the implementation phase and trying to get all the stakeholders to then agree on what the form looks like. If it's in the law, it's done, and nobody else has to worry about it, and it can be the same for the whole state. And it's helpful if the laws are combined. So if educational and health care together, and only one affidavit is needed. And that's for obvious reasons, because then you've only got one form to submit to people. And often, medical care, health care, the schools need to know, have immunization requirements and need to know who the child's doctor is and make sure that you can access that health care. But whether the laws are combined is not as important as if the forms are readily available. So you want to have these forms, at schools. You want to have them where the caregivers are so they know how to do this and that it's an easy process. And an interesting little fact here is that the West has more joint consent laws than any other region in the country. And on the next slide, you'll see an example. This is from California, and I pulled it off of the website down at the bottom, and I love it because you can just complete this online. And we know a lot of caregivers don't have access to computers, but there are usually people in their lives who can help them, or in libraries they can go to get access to a computer. But you'll see this form is super straightforward. It's just, the name of the child's birth date, the caregiver's name, their address, and then, they have to meet the definition of what a relative is. So they check that. And then you'll see that there are a couple of things that address the parents. So they've advised the parents and there's no objection, or they're unable to find the parent and notify them. Their date of birth, the caregiver's date of birth, and then their identification card. And then you'll see the warning, the penalty of perjury, the crime that they'll be guilty if it's fraudulent. And then they date it and sign it, and then that's it. It's a very straightforward form, and then they take that to the healthcare provider or to the school and access those services for the child. One of the important things that we think these laws should do is cover comprehensive health care services. So some of these laws, some of the states, and maybe we're being a little overgenerous when we say that 25 have the health care consent laws, because some of them are quite narrow, but we tried to be fairly selective there. But we believe it should include immunizations, all kinds of health care, so making sure mental health care is in there, developmental screenings, and occupational speech and physical therapies, because a lot, and unfortunately we don't have a firm statistic on this, but we know anecdotally that a lot of children in kinship care have special needs, usually because of the situations they came from, but they often have special needs. And I shouldn't say usually, but they do have special needs. Anyway, Washington State, which we're going to learn more about later from Judy, includes mental health care, and that is something they went back and put in there. And anecdotally, talking to other states, it's just an omission. There's no controversy around including it that I've run across. It's just, basically the legislature forgot. There's no big drama around that. Covering comprehensive educational services also. So not just the educational enrollment, but all the things that go along with that. So you'll see a couple of examples here. Discussing with an educator the progress of the child, so being able to be part of those parent-teacher conferences, to get the emails from the parents, from the teachers about the student, to get news from the principal about the student, all those kinds of things. And in Hawaii, I believe they were the only state who was so clear about this, but that it includes consenting to full participation in the extracurricular school activities. You can also include things in your law that it'll include consenting to special education services, which under federal law, our caregivers are allowed to, without a legal relationship, be part of that whole IEP, individual education plan process. But some states make them go through hurdles. But anyway, just laying it out in this law, again, can't hurt. So really covering all of those comprehensive educational services. Then, not requiring parental signatures. This is huge for the reasons that I stated before. Sometimes you just can't find the parents. Sometimes the parents are unwilling because they might have mental health issues and it's a legal document and that's scary. Whatever the reason might be. And you'll see there are a couple of states that ask for them, but then don't require them if the parent can't be found. So that might be an approach. If parents' rights oppose this, you could take that approach. There are a lot of strategies in here that you could copy from other states, to respond to whatever your particular state's concerns are or opposition is. Addressing parents' rights, which is the next slide, which feeds into that. And that language can be included in the notice section. That's where states put it, in the notice of the affidavit. So usually, I showed you California's, but I didn't show you the back side of it, which has a lot of notices on it. And these notices usually have things like what I quote here from New Mexico, that it doesn't confer legal custody on the caregiver signing the affidavit, and that the parent, can always rescind it. So really protecting those parental rights and making it clear to all involved that this does not mean the caregiver is now the legal custodian. It just means they can access these services for the child. Now, interesting, a couple of states, they clarify the issue of conflicting decisions between a caregiver and a parent. So what happens if a caregiver says one thing and they've got consent, and then the person, the healthcare provider, the school, knows that there's a different decision that a parent is taking? Well, the parent decision trumps, except for, and you'll see here, if the parent's decision endangers the life of the child. So then they can require some proof. So kind of making that clear again, it's a way of addressing parents' rights, that if there are conflicting decisions, the parent always trumps the caregiver. Shielding schools from liability. Typically in this realm, the biggest opposition to these laws come from the K-12 groups. And it's for those legitimate concerns that are raised by the residency requirements. So trying to protect people from school shopping if you don't have an open enrollment state. Sorry, I lost my train of thought there. So protecting them from that kind of liability. Now, what we can do here is include language like it's in Hawaii's law to protect them, so that they don't rely on the affidavit. They don't need to, that they won't be subject to any kind of liability or disciplinary action because they relied on the affidavit. So, protecting them against that and making clear, again, that it's the protection's extended to where the parent would have made an opposite decision. But the school didn't know. That's an important part. The school didn't know. And then specifying penalties for fraudulent consent. And I think this is where I got myself confused a little bit a minute ago, and I apologize. But this is the situation where you're protecting the healthcare providers and the you're protecting everyone from fraud. So anyway, most times, and we really haven't heard any states say they have problems with this. I have not heard a single anecdote of perjury, of holding a caregiver responsible for perjury, or of having any concerns that perjury's been committed. There may be some out there, but I haven't personally heard from them. And usually, just saying that they're going to be subject to penalties for perjury is enough to deter people. That's been the experience and the feedback I've gotten. And you can see here's an example of one of these protections, these statements about not committing perjury. So, and in Montana's law, it's in big, bold, capital letters, just like I wrote here. And that's a way to ensure that there's not fraudulent consent. Now, usually under educational consent laws, these penalties are more prescribed. And this is for all those residency requirement reasons and preventing people from shopping for schools. So a lot of states would make, if a caregiver was found to have committed fraud and not really be caring for the child full time, but really just their address, say, is being used so that the parent can enroll the child in what's perceived to be a better school or something along those lines, that the caregivers could be subject to monetary penalties, to school tuition costs, so the cost of that public school tuition, they'd have to repay it. In Maryland, we just learned this morning, it's 3 times the cost of tuition is the penalty for fraudulently using that law. But that lawyer this morning said that she's never known anyone who's been charged that tuition penalty because there just hasn't been any fraud that we know of. And in New Jersey, if this is a big issue and the K-12 community is giving you a hard time in your state, in New Jersey they go a little bit further, and they actually give the school board the authority to remove the student and to impose the penalties. Because what you find is a lot of states, the criminal justice systems are overwhelmed, and they're not going to really go after perjury on an affidavit form, right? But in New Jersey, the school board can actually do it. So they can impose those penalties if they find that there is perjury or fraud. So that's another approach if you're finding that your state K-12 community is particularly concerned. But as another advocate pointed out to me, there really are systems in place already for preventing school shopping. And really, if that's your motive, are you going to file an affidavit and flag yourself as someone to look at with more more carefully? Probably not. You're going to try to fly under the radar. So I don't think this is the population school districts have to fear. It's more parents looking for better schools, not this population. Allow the consent authority to be valid until rescinded. So like Hawaii, don't put an automatic time limit. At least this is what we recommend. And again, if you have to make concessions to get these bills passed, that's okay. It's better to have a 1-year limit than not to have these laws. but it's better if it's just open-ended until the parent or the caregiver rescinds it, so that the caregiver doesn't have to refile it every year, take it to the doctor again every year, just go through yet another level of hassle. That's what these laws are designed to avoid, is hassle, and make it easier on them, make it easier on them. And then permit all full-time caregivers to complete these. So by that, I mean not just people who are related by blood, marriage, and adoption, but also people who are raising children who are family friends or godparent, the caregiver's the godparent, where there's a bond like family, like they feel like they're family, but they're not technically family. And most states do allow all caregivers to complete these affidavits. Only 5 limit their consent authority to blood, marriage, and adoption, and only 1 limits it to grandparents. That's Ohio, and I think they're trying to expand that. So elements to avoid. There are not as many of these as there are elements to include, but there are a few when reading through all these laws and thinking about it. And we don't want school districts to decide whether to accept the affidavit. So don't, the state law shouldn't leave it to their discretion. It should be, this is going to apply statewide. Not require sworn statements from the parents. Again, these laws are intended to address those people who can't find the parents, who can't get their parents to cooperate. That's that population, and minimize documentation requirements. So the less they have to produce with the affidavit, the better. Now, in terms of not allowing local school districts to decide whether to accept them, to my knowledge, the only state that does this is Oklahoma, but they say that, it's left to the local school district whether or not to accept it. And so I was sharing this morning that I was at the Brookdale Foundation Group's Relatives as Parents program this weekend talking about this a little bit, and there was a woman in the audience from Oklahoma, and she said, I don't have this in my district. Why not? And I said, that's because it's left discretion. So, that's just really not fair, for lack of a better word, to let some caregivers use them and some not. Don't require sworn statements from the parents. So this is just kind of delving into the parent's personal business, in my opinion. Like, why should parents admit to essentially failure and say, I can't care for this child, and that's why they're with grandma, and it's not they're not with grandma just to obtain an education. It's because I'm a loser. I mean, that's basically what they're requiring them to say. And this is just, it's degrading, and it's not necessary. Virginia allows local school districts to require such statements. Allows them, but doesn't require them to. But again, if you can avoid this, I think it's better to avoid it. And then don't have onerous documentation requirements. This is something we've heard before. Other states have struggled with this, where there are a couple states that have had kind of a laundry list of reasons why the parents aren't raising the child, and making them check it and then making them document it. And again, it's getting into personal business. It's also sometimes really hard, if not impossible, for caregivers to show, because there are all kinds of HIPAA requirements, federal health care privacy protections that prevent them from getting that information and sharing that information. So, as I said, there's really not that instances of fraud here. So these levels of protections are too much. Now, reasons some states may lack consent laws, because as I said, about half don't have health care, and more than half don't have educational consent. And there are several reasons for this. Alternative methods. Some states may not need them, and that's up to you to assess whether or not your state needs it. But in a few states, Indiana and Rhode Island, the child's residency is where the caregiver lives. So if that's the case, perhaps you don't need it. There's also consent for military families, which I'll get into a little more detail, and power of attorney laws, which, as I pointed out, isn't a reason not to have these, and open enrollment laws. There are also parents' rights and actions. So getting into this in a little more detail, the alternative methods to enroll the children in school, as I said, Rhode Island and Indiana have that, the child's residency is where the caregiver lives. So maybe they don't need those laws. Now the second big one is the consent for military families. And this is interesting, this interstate compact on educational opportunity for military children. Most of the states, the vast majority, over 45, and I don't know the latest number, but over 45 states have adopted this interstate compact. And it is a much more comprehensive law than what we're talking about today. So for that subset of kin family, it is an excellent option because it gives them not only the power to consent to educational enrollment, but it gives them, say, a high schooler has moved from Alabama to Georgia to be with their grandma while their parents are deployed or in the military, then they can, their graduation requirements, all the requirements associated with graduating, with what they need to take in school, et cetera, are from their home state. So that you wouldn't find a child suddenly in high school being subjected to a lot more requirements or different requirements than they had been under in their home state. So this is the way to go if you have a kinship family who's formed because the parents are deployed in the military or in a base in another state and grandma's taking care of them. So for that subset of kinship families, it's a great law, a great educational consent law. But that is just a subset of our families. Many of our families are formed because of substance abuse issues, because the parents are substance abusers, because the parents are incarcerated, because the parents are dead. I mean, there are many, many reasons other than military deployment for military families. Power of attorney laws, as I talked about before, because they require action by the parents, consent laws are still necessary. And ditto with the open enrollment laws. You need the parent to enroll them, so consent laws are still necessary in that circumstance too. So it's really up to an individual state to kind of determine if you need these laws, and that's the first step in doing these laws is really kind of collecting the anecdotes, getting the personal stories of the need for these laws. And it can be hard because families are private. In Kentucky, they conducted focus groups to really identify that need and to document it. Tools and strategies to enact consent laws. There are a number of tools and strategies. And we've touched upon some of them already, but educating that existing alternatives are not enough. So like what we just talked about, the power of attorney, the open enrollment, protecting parents' rights, involving educational stakeholders and responding to them concerns from the beginning, making clear that these laws are cost neutral, that's huge, protecting against liability and fraud, using community partners to help advocate, separating educational from healthcare consent laws. If the educational is proving to be a bigger hurdle to enact, separating them and enacting healthcare first. That's what Maryland did. And then sharing personal stories. I mean, there's just no substitute for sharing the personal stories and the anecdotes and the real-life stories. Educating that existing alternatives are not sufficient, really making that case that the power of attorney and the open enrollment laws aren't responsive to those families who can't find the parents and who can't obtain their cooperation. Protecting the parents' rights. So ensuring that their notice provisions on the consent forms themselves say, this does not confer legal custody. The parent is still paramount and can still rescind this and can still contradict it. And asking for their signatures can be a compromise. And as I said, I mean, these laws are important enough that if you have to make compromises on certain things, it's still the way to go. But just make sure that they're not required, because then that really wouldn't address most of our families or many of our families who can't get the parents or don't know where the parents are to do that. Involving educational stakeholders, really involving them from the very beginning. So before you've introduced any legislation, find a couple of school leaders who acknowledge the problem and are wanting to help you. In Kentucky, they were able to find a school principal who actually helped them write up the stories, personal stories of the caregivers that were having problems accessing educational services. So there are, schools want to do the right thing. They just need to protect themselves too. So you'll find people that'll help you, and they can identify the challenges too, and how you're going to overcome them. Who the potential problem opponents are, how to navigate that, and involve them throughout the process. And you can respond to their concerns with strict penalties, like they did in New Jersey, and Maryland too, for that matter. And you can consider whether to include a process to challenge the statement. So that would be like what New Jersey has, where they can actually impose the penalties themselves. So there are ways to address all these concerns, and the policy brief, which I'll point out to you later, has a lot of more specific examples too. So you can find a way to respond to any opposition, I think, by using other states and not having to reinvent the wheel. Making clear that these laws are cost neutral. That can't be emphasized enough, because state legislators are hearing more and more about kinship families. The media is portraying them more and more favorably. Back 20 years ago when I started working on this stuff, families were being portrayed as apple doesn't fall far from the tree, so why should we support grandma when she messed up with her own child? That kind of frame was being used around these families, and now it's more the heroes that they are, that they're stepping forward and they're caring for these children. They're saving taxpayers billions of dollars. They're keeping children out of foster care, all those positive frames. So the legislators are hearing that, and they're hearing more and more from kinship families, and they want to help them, but they also need to work in the reality of their own situation, which is state budgets are really tight. So this is a way for them to help the families without incurring any more costs, because there's no program to implement, there are no salaries to be paid, and there are no costs associated with this other than maybe making printed copies of the form and having them available at various places. Protecting against liability and fraud, all of those things we talked about before, about protecting schools and healthcare providers. So protecting them from liability, protecting them from professional discipline, but making sure too that that healthcare providers can still be held liable for negligence. This isn't like a get away with anything pass. This is just protecting them from relying on the consent. So the consent shields them, but not any behaviors that they do, any medical malpractice that they might engage in, aside from that consent issue. And then using those penalty provisions to protect against fraud, especially with respect to the school where there seem to be more concerns. And using community partners to help advocate and sharing personal stories. So, the personal stories are just incredibly powerful, and that's really how we move things. I've heard a couple lately. One I heard from Kentucky where this little baby desperately needed tubes in his ears, but the doctor refused to put them in because of consent issues, that the grandma couldn't consent. So, and they could not find a parent. So that little baby went 6 months without ear tubes, and anybody who knows about that, who's had that experience, that can really have a lifelong impact. And then another one about educational consent. I hear those all the time, but one that's particularly compelling to me is that a lot of times you can enroll the child in your school without a consent law or at least sometimes, if, say, that grandma's lived in that community for decades, they know everybody at the school, maybe they work in the school, and everybody in the school knows that Betty raises her grandchild. So Betty probably is not going to have any trouble enrolling that kid in school. But these laws really help those families that don't have that kind of connection and luck, basically luck. And this equalizes the playing field and lets all these heroic caregivers enroll the children in school. So in Maryland, a caregiver had been raising her grandson since he was an infant, and she was able to enroll him in elementary school and middle school no problem because everybody knew her. But then when it came to the high school, they refused to admit him. And so he was staying home from school because they wouldn't let him go. And the caregiver knew enough to call a very advocate in the state of Maryland, and the educational consent law there had just passed. So this advocate armed herself with the law, drove down to this rural community, got Grandma and the boy in the car, and the three of them drove over to the high school, presented the affidavit, and he started school that very same day. So it's stories like that that can really help you enact your laws. And then using all the community partners you can get on board. So, you know, here's a list, but there are so many others. And one of the most important groups to get involved are the legal aid lawyers. And this is where I'm going to turn it over to Judy to tell you about Washington's healthcare consent law. Thank you, Judy.
Thank you, Anna. So Anna's asked that I give a little bit of an overview of the Washington State Healthcare Consent Law and some history of how it was enacted. And I think what helped our community tremendously was that there was a real supportive environment in the legislature. It started with our legislature as far back as, I think, 2001, where they recognized the prevalence of kinship families and asked their research arm to conduct a study and provide a report to the legislature about their key findings. And luckily for the community, it included findings that there was a need for healthcare educational consent laws. That study helped support the argument that consent laws were needed for those kinship families to overcome the barriers that Anna's been discussing in this training. From that report, the legislature mandated the creation of the Kinship Care Oversight Committee, and that was comprised of representatives from different state agencies, such as our Children's Administration, Economic Services, Aging, and it also was very broad in terms of encompassing advocates from the legal community, the social service community, kinship caregivers themselves who had the wonderful, powerful stories. And this committee was able to review the report that was given to the legislature and reaffirm what those recommendations and findings were. And so we were armed with some great information to start the work of working on a healthcare consent law. And I think it was a strategy to focus on healthcare consent first. And because of that, it was really important, as Anna's mentioned, to involve key stakeholders. And so what occurred was the Washington State Medical Association, the Washington State Hospital Association were included along with folks from the Kinship Oversight Committee to talk about what the proposed legislation might look like. And so although, again, we didn't tackle education consent law with the healthcare consent law because of strategic issues, I think the education consent law issue still is an important one, but we have not yet addressed it statewide. So the Washington Healthcare Consent Law was enacted in 2005, and again, going back to our collaborative process, I think that really helped us pass the legislation without any real formal opposition to the legislation. There were two issues that were a bit ambiguous when the law was initially enacted. One was the definition of health care and whether it included mental health care or not. And I don't think that was an intentional ambiguity. It was really a matter of how different folks interpreted the statutes and how they read it with statutes specifically related to mental health. So the initial law was, healthcare consent law was passed, and then the following year, just to be clear, the law was amended to specify that mental health care was included. The other issue that was left undefined was the definition of relative. So the Washington healthcare consent law does say that relatives can consent to health care. But the legislation does not, the law does not say who qualifies as a relative. So for example, does it include step-grandparents? Does it include sort of the fictive grandma, maybe someone who is the foster grandma for the mother? The law does not define that. I think there was a feeling that if we tried to make a definition, it would be a barrier to passing potentially the legislation. So it was left undefined. And fortunately, I've not seen it as a big obstacle in implementing and getting healthcare consent. So how the law works in practice. So from my experience, I hear from kinship caregivers who don't have legal custody and are worried about whether they can consent to health care. They want to be prepared. Or maybe the child they're caring for has ongoing health care issues that they want to make sure that they can address. In other instances, I hear from caregivers who have tried to obtain health care for a child but have been told by the medical provider or by someone else that they need to get legal custody in order to consent to the health care. And for both groups, educating them about the healthcare consent law is important, because so many of them don't even know that they have the power to do this. There's a brochure that we developed in conjunction with other stakeholders that has a question and answer format about the law and includes a sample declaration that a caregiver can use. And we'll look at that in a few minutes. But it is really simple. It has some very basic information. And sometimes that knowing that this law exists is all that the caregiver wants. They're not interested in pursuing legal custody for many of the reasons that Anna mentioned earlier. It can be expensive, it's hard to find legal representation, it's an emotional process, etc. So they are at least armed with the brochure, the sample declaration, and armed with the knowledge that they have this ability to consent. For those caregivers who want to pursue legal custody, it could be that interim, having that information, having the sample declaration, and can be an interim measure prior to actually commencing a custody or guardianship process. And we fortunately have a program here where we screen cases and are able to refer them to volunteer attorneys who can help them with that custody process. So implementation obstacles, again, I think educating caregivers and the healthcare community is important. When the law was first passed, the Washington State Medical Association and the Washington State Hospital Association both sent advisory letters to their members informing them about the passage of the law. But it's been several years since then, and it's unknown how much educating is going on in the medical community. And luckily, when there have been many times where caregivers have called me, who've been told that they were told by the medical provider that they need legal custody, and when I share the brochure with them and the declaration and ask them to share it with their medical provider and call me if they have problems, fortunately, I have not been getting those calls back. So I'm pretty hopeful that the information is being well received. However, there is a main drawback of the Washington state law, and that is that the language is permissive rather than mandatory. So it says that a health care provider may accept informed consent by a relative, but it doesn't say that a health care provider is required to accept it. And the times where I've seen it be an obstacle has been with our local children's hospital. They have no, I've spoken to them, they have no issues regarding routine health care or even emergency health care. The one area that they've carved out where they are not accepting healthcare consent from a caregiver is regarding elective surgeries. I think there was a concern about a particular case where they did perform an elective surgery where a parent complained that there was no effort to try to find them and consent to the surgery. And so the hospital's reasoning and reading of the law is, well, the law is permissive, but doesn't require the provider to accept the consent. So that is the only area where I've seen it be an obstacle. So here is an example of a declaration that we have included in the brochure. It looks a lot like California's because we did use that as a model, but it actually, I think, even has less information in it than the California form. Again, it's very simple, the key point being that the relative is indicating that they are a relative responsible for the health care of the minor. It's signed under penalty of perjury. Our statute does say that it's only valid for 6 months, but there is no limit in terms of how often a caregiver could complete another declaration. Our statute says that can or may require a declaration, but the provider does not have to. So although the declaration may be provided, again, a medical provider can choose not to require it. On the backside of our sample declaration, we do include several statements and notices that Anna referred to as being helpful to have in terms of trying to pass healthcare educational consent laws. So we do include on the back of the declaration a statement about it not conveying legal custody, that it does shield a medical provider from liability if they rely on the declaration or statements made by the relative. So it does include those things. And then lastly, here are 2 resources where the brochure and sample declaration can be found on the internet. One is at the Washington Law Help, which is a wonderful statewide legal resource site that has a lot of information on various legal matters, a lot of self-help materials, including family law and other health issues, benefits issues, etc. It's posted there, and then also at our DSHS website is also has the brochure. And it's also available to be ordered. So organizations in the community can order for free a stack of the brochures that they can hand out to kinship caregiver providers. So that is all I have.
Thank you so much, Judy. And I'm just going to take you through a few national resources as well. On the next slide, you will see the front page of our policy brief, and it talks a lot about what we talked about today, and it also goes into a lot more detail and cites a lot more states. So feel free to use that as a resource. It's available on both those websites down at the bottom, and it's available for free, so please use it. Please contact me with any questions. I'm glad to help in any way I can. If you want to amend your law to make it more responsive, or if you want to pass a law. I was able to help Kentucky quite a bit. It was very enjoyable from my perspective. On the next slide, you'll see a few websites that are available as well. Grandfamilies.org has all these state laws on it, at least a blurb about them, and then it'll link you to a place where you can download the entire law. It also has analyses in a lot of different legal topic areas, including this one, although the brief is more comprehensive, so I would rely on the policy brief in terms of analysis. Also, the grandfactsheets.org there at the bottom. That is, if you go to that website, there's a drop-down menu, and you can select your state, and it provides a lot of state program information and policy information on those. So they can be useful as a resource. They're a bit out of date, but they're a very useful first step in helping kinship families. And then, of course, our own website, the gu.org website, that's got the policy brief on it, summary. It's got a lot of information on it, the latest goings-ons. And you can, on the home page, on the right-hand panel, you can register for e-alerts for free, and that will give you the latest policy information, if you like it, mostly at the federal level. So it's a good way to stay connected with what's going on in kinship care. And the next slide is a link to the Brookdale Foundation website, which they are the largest national network of support groups for relatives raising children and for support services for relatives raising children. And they're in almost all the states in Puerto Rico and D.C. And then finally, the AARP.org quick link, which if you're working with grand families or you are a grand family that needs information about what programs you may be able to access, it can provide you information specific to your family. And it's an important resource because a lot of families aren't accessing benefits they could be accessing. An interesting fact is that only 12% of kinship families access TANF child-only grants, the Temporary Assistance for Needy Families child-only grants, even though almost all the children in those families are eligible. So there are a lot of resources out there that maybe can be used for these families. So on the last slide, you will see my email address, Judy's email address, Jaya's email address. So please reach out to us with anything. As I said, Generations United has some funding to provide free technical assistance around these issues. So please feel free to reach out to us, and we'll help you as we can. And I will now turn over to Jaya to mediate a Q&A session.
Great. Thank you, Anna and Judy. So we want to start just to remind people that after this PowerPoint, or after this webinar is over, we will be sending up a follow-up email to all of you who have registered with a link to the recording of the webinar if you're interested in sharing it with others who might not have been able to participate, and a link to the PowerPoint if you'd like to just download just the PowerPoint and have that available. We'll do that as well. So that's coming. So one of the first questions that we got here is a question about what is the process for parents to rescind the consent if they contest it, and what is the court process for that?
You want to start with that, Judy, and then I'll take over, whatever's specific in Washington?
Well, there's no specific process that's outlined in our laws about how a parent can rescind a caregiver's consent. I think it could be as simple as the parent contacting the medical provider and letting the medical provider know, either verbally or even in writing. I mean, again, the healthcare consent law does not convey any other legal rights, so the parents still retain their parental rights to make decisions about education and medical care. So it's not a court order where the court is saying parent, you no longer have the authority. It is in addition to our informed consent laws, which looks to parents' consent, but it also looks to if a parent's not available, then the relative's ability to consent.
Yeah, and what Judy's talking about in Washington really applies in most states, and with respect to educational consent as well. You just, the parent goes to the school and tells them that I am parenting now and rescinds that consent, and goes to the healthcare providers and does the same. There is one state, Ohio, that has a process, a more formal process. But the downside with that is that caregivers are required, actually it's just grandparents in Ohio, but grandparents in Ohio are required to file the affidavit with the courthouse within 5 days of doing it. And there's no filing fee, but they have to file it. And then if the parent wants to rescind it, then they go and they can do it through the court. And the court can then have a hearing to determine if it should be rescinded and decide based on the best interests of the child whether or not it should be rescinded and whether or not the child should stay with grandma. So it's almost like a combined consent law, de facto custody law. It gives the caregiver some more rights and allows them to go to court and kind of contest the parent's action. So that's another approach.
Great. Okay. And then the next question, I think this one's for Judy, is have you seen any fraud with the law in Washington?
I'm sorry, what was that? Have I seen any?
Any fraud?
Fraud? No, I mean, I have not heard of any instances of fraud. But, you know, there may be a case out there that I haven't heard about, but it's not a concern or a worry that I've heard.
And I'll echo that. I haven't heard of any in other states either.
Great. And then the next I'm going to combine two questions related to implementation. And that was that Judy highlighted that one of the biggest implementation obstacles was lack of awareness. And wondering if there are any strategies in other states that we're aware of about how to effectively get the word out about these laws. And combined with that is just important things to be aware of during the implementation phase. So maybe I'll put the first one to Anna to see if we have anything in other states about ways to get the word out.
Well, the best way to get the word out is just to work with all those stakeholders from the beginning and have them disseminate it to their networks and make sure that these forms are available in all the places that caregivers go to. So I loved, and I hadn't heard before, the Washington Medical and Hospital Association sending out letters to their members. I'm going to tell Kentucky about that one because I like that.
Great. And is there anything else in terms of key items to consider in the implementation phase, Judy, that you might share?
Well, I think where we've benefited a lot, again, is that we've created a very strong kinship community. So we have a collaboration that's local to the county I'm in, but then there's also the statewide kinship oversight committee that I mentioned. And again, by building that, not just to only address the healthcare consent, but to address and discuss and strategize about all issues that impact kinship caregivers, really has provided a wonderful way to disseminate information, especially if you're looking at those key stakeholders who have maybe helped pass legislation in your state, or you hope to pass legislation in your state. Starting to make those connections will really help, I think, in any implementation process.
Yeah, I would ditto all that as well and say that, I mean, and commend Washington for doing that pamphlet, too. I mean, I think that, and if I understand correctly, it was translated into something like 8 languages. So really getting it out in the community in a way that people understand it. And another big thing that I hear is what I said briefly during the presentation was including the form in the law. It just makes it a lot easier. You don't have a million different versions of the form out there. You don't have people fighting over what the form should say. Just putting it in the law is another big implementation strategy.
Great. So now we have a couple of questions that are actually related to the educational consent. And one is there is a school district elevated in Washington State that doesn't allow students who are not in the legal custody of a caregiver to participate in extracurricular activities. And have you seen any special ways of addressing this situation?
Judy, would you like to start with that? I'm just in terms of Washington specific, perhaps without the consent, since it doesn't have a consent law. Is there anything they could do?
Specifically to extracurricular activities, I mean, I haven't heard about that being raised separate from just enrolling a child in school. I mean, assuming that a parent isn't available to sign any kind of broader consent regarding school or extracurricular activities. I'm not sure what other strategies could be available. One law that I fall back on for kinship families, since we do not have an educational consent law, is looking at whether we can rely on the federal McKinney-Vento Homeless Education Act to get kids enrolled. It's a great tool to get children enrolled in school who are either just newly placed with a kinship caregiver. Maybe they're fleeing abuse in the home. Maybe it's a youth who's run away from home because of abuse. I mean, the Homeless Education, the McKinney-Vento Homeless Education Act is really a useful tool to get kids enrolled. And here in Washington, we have homeless liaisons at each of the school districts who are, that's their role, is to help that community. And certainly that could be extended to extracurricular activities. The limitation, though, of the McKinney-Vento Act is that it really isn't intended to address the circumstances where many of our kinship caregivers are, where you know, they've been providing care, they have been the caregiver for quite an amount of time, and making the argument that McKinney-Vento should apply in that case is a little bit of a stretch. But again, I think it's a case-specific argument that could be made. But other than that, I really don't have any other strategies to address that particular issue.
And then in terms of states that do have educational consent, most don't specifically call out extracurricular. It's kind of something that goes along with educational enrollment in most school districts. But you would have to look at how your school districts in your state are set up, and if that is something that goes hand in hand. If it's not, you might want to do what Hawaii did, which is really pull it out as something that is highlighted on the affidavit and in the law, that the consent includes the consent for extracurricular activities. And that law is in the brief and on one of the slides that I showed you earlier. So you'll have that.
Great. And then the last question I have here is, do educational consent laws typically cover early intervention for children that are not yet school-aged as well?
Well, that's an excellent question. And have you noticed how people say that's an excellent question when they don't have the answer for you? So that's what I'm going to tell you, is I don't have the answer for you. I did not see that anywhere explicitly, but I am going to take a look and I will get back with you. Jai, you've got their email, right?
Yep.
Okay.
Got it.
I will do that. I did not see it explicitly called out anywhere.
Great. All right. Well, with that, I think we may end just a few minutes early. So again, I'd like to thank our presenters, Ana Beltran and Judy Lynn. Folks have our contact information on the screen if you have any follow-up questions that you weren't able to get to us today. And as I mentioned, we will be sending along a link to the full webinar in addition to a way to download the PowerPoint presentation. So thanks to our presenters, and we look forward to the follow-up communication. Bye-bye.
Thank you, everyone.
Thank you.